Greetings, respected guests, and welcome to the Washington Center for the Performing Arts. Today's event is not intended to be partisan in any way. Sponsors for this event include Oli Arts Magazine, Bowser's Books, the Northwest Playwrights Alliance, TC Media, and the Washington Center for the Performing Arts. Over the course of the day, a variety of readers from our local government and community will be reading 30 minutes of materials from the document known as the Mueller Report. Each reader has been asked to present the material without commentary, and transitions between speakers will be very brief. When a reader comes to a section of text that has been redacted, they will indicate so by ringing a bell. We hope you find this information useful and enjoyable.
Whether the statement was made to law enforcement or congressional investigators, the government must prove beyond a reasonable doubt the same basic non-jurisdictional elements. The statement was false, fictitious, or fraudulent. The defendant knew both that it was false and that it was unlawful to make a false statement, and the false statement was material. See example, United States versus Smith, A31, F3D 1207, 122, and 27, 9th Circuit, 2007, listing elements. See also 9th Circuit Pattern Instruction 8.73 and comment, explaining that the Section 1001 jury instruction was modified in light of the Department of Justice's position that the phrase knowingly and willfully in the statute requires a defendant's knowledge that his or her conduct was unlawful. In the D.C. Circuit, the government must prove that the statement was actually false. A statement that is misleading but literally true does not satisfy Section 1001A2. See United States versus Milton, 8F3D 39, 45, D.C. Circuit 1993, United States versus Dale, 991 F2D 819, 832 33, and N22, D.C. Circuit 1993. For that false statement to qualify as material, it must have a natural tendency to influence or be capable of influencing a discrete decision or any other function of the agency to which it is addressed. See United States versus Gaudin, 515 U.S. 506, 509, 1995. United States versus Moore, 612 F3D 698 701, D.C. Circuit 2010. Perjury. Under the federal perjury statutes, it is a crime for a witness testifying under oath before a grand jury to knowingly make any false statement in material declaration. See 18 U.S.C. Section 1623. The government must prove 4 elements beyond a reasonable doubt to obtain a conviction under Section 1623A. The defendant testified under oath before a federal grand jury. The defendant's testimony was false in one or more respects. The false testimony concerned matters that were material to the grand jury investigation, and the false testimony was knowingly given. United States versus Bridges, 717, F2D 1444, 1449, and 30, D.C. Circuit, 1983. The general perjury statute, 18 U.S.C. Section 1621, also applies to grand jury testimony and has similar elements, except that it requires that the witness have acted willfully and that the government satisfy strict common law requirements for establishing falsity. See Dunn versus the United States, 442 U.S. 100, 106, and N6, 1979, explaining the two-witness rule and the corroboration that it demands. Obstruction of justice. 3 basic elements are common to the obstruction statutes pertinent to this office's charging decisions. An obstructive act, some form of nexus between the obstructive act and an official proceeding, and criminal, i.e. corrupt, intent. A detailed discussion of these elements and the law governing obstruction of justice more generally is included in Volume 2 of the report. B. application to certain individuals. George Papadopoulos. Investigators approached Papadopoulos for an interview based on his role as a foreign policy advisor to the Trump campaign and his suggestion to a foreign government representative that Russia had indicated that it could assist the campaign through the anonymous release of information damaging to candidate Clinton. On January 27, 2017, Papadopoulos agreed to be interviewed by FBI agents who informed him that the interview was part of the investigation into potential Russian government interference in the 2016 presidential election. During the interview, Papadopoulos lied about the timing, extent, and nature of his communications with Joseph Milsford, Olga Polonskaya, and Ivan Timofeyev. With respect to timing, Papadopoulos acknowledged that he had met Milsford and that Milsford told him the Russians had dirt on Clinton in the form of thousands of emails. But Papadopoulos stated multiple times that those communications occurred before he joined the Trump campaign, and that it was a very strange coincidence to be told of the dirt before he started working for the campaign. This account was false. Papadopoulos met Milsford for the first time on approximately March 14, 2016, after Papadopoulos had already learned he would be a foreign policy advisor for the campaign. Milsford showed interest in Papadopoulos only after learning of his role on the campaign, and Milsford told Papadopoulos about the Russians possessing dirt on candidate Clinton in late April 2016, more than a month after Papadopoulos had joined the campaign and had been publicly announced by candidate Trump. Statement of Offense 2526, United States versus George Papadopoulos, number 17 CR 182, DDC, October 5, 2017, document 19, Papadopoulos Statement of Offense. Papadopoulos also made false statements in an effort to minimize the extent and importance of his communications with Milsford. For example, Papadopoulos stated that Milsford is a nothing, that he thought Milsford was just a guy talking up connections or something, and that he believed Milsford was BSing, to be completely honest with you. In fact, however, Papadopoulos understood Milsford to have substantial connections to high-level Russian government officials, and that Milsford spoke with some of those officials in Moscow before telling Papadopoulos about the dirt. Papadopoulos also engaged in extensive communications over a period of months with Milsford about foreign policy issues for the campaign, including efforts to arrange a history-making meeting between the campaign and Russian government officials. In addition, Papadopoulos failed to inform investigators that Milsford had introduced him to Timofeyev, the Russian national who Papadopoulos understood to be connected to the Russian Ministry of Foreign Affairs, despite being asked if he had met with Russian nationals or anyone with a Russian accent during the campaign. Papadopoulos Statement of Offense 27 to 29. Papadopoulos also falsely claimed that he met with Polonskaya before he joined the campaign and falsely told the FBI that he had no relationship at all with her. He stated that the extent of their communications was her sending emails, just, "Hi, how are you?" That's it. In truth, however, Papadopoulos met Polonskaya on March 4, 2016, after he had joined the campaign. He believed that she had connections to high-level government officials and could help him arrange a potential foreign policy trip to Russia. During the campaign, he emailed and spoke with her over a Skype on numerous occasions about the potential foreign policy trip to Russia. Papadopoulos Statement of Offense 3031. Papadopoulos' false statements in January 2017 impeded the FBI's investigation into Russian interference in the 2016 presidential election. Most immediately, those statements hindered investigators' ability to effectively question Milsford when he was interviewed in the lobby of a Washington, D.C. hotel on February 10, 2017. See Government Sent Memo at 6, United States versus George Papadopoulos, number 17CR182, DDC, August 18, 2017, document 44. During that interview, Mifsud admitted to knowing Papadopoulos and to having introduced him to Politkovskaya and Timofeev. But Mifsud denied that he had advanced knowledge that Russia was in possession of emails damaging to candidate Clinton, stating that he and Papadopoulos had discussed cybersecurity and hacking as a larger issue, and that Papadopoulos must have misunderstood their conversation. Mifsud also falsely stated that he had not seen Papadopoulos since the meeting at which Mifsud introduced him to Politkovskaya, even though emails, text messages, and other information show that Mifsud met with Papadopoulos on at least 2 other occasions, April 12th and April 26th, 2016. In addition, Mifsud admitted that he had drafted or edited the follow-up message that Politkovskaya sent to Papadopoulos following the initial meeting, and that, as reflected in the language of that email chain, "Baby, thank you." Mifsud may have been involved in a personal relationship with Politkovskaya at the time. The false information and omissions in Papadopoulos' January 2017 interview undermined investigators' ability to challenge Mifsud when he made these inaccurate statements. Given the seriousness of the lies and omissions and their effects on the FBI's investigation, the office charged Papadopoulos with making false statements to the FBI in violation of 18 U.S.C. Section 101. Information, United States versus George Papadopoulos, number 117 CR 182, DDC, October 3rd, 2017, document 8. On October 7, 2017, Papadopoulos pleaded guilty to that charge pursuant to a plea agreement. On September 7th, 2018, he was sentenced to 14 days of imprisonment, a $9,500 fine, and 200 hours of community service. Michael Flynn. Michael Flynn agreed to be interviewed by the FBI on January 24, 2017, 4 days after he had officially assumed his duties as National Security Advisor to the President. During the interview, Flynn made several false statements pertaining to his communications with the Russian ambassador. First, Flynn made 2 false statements about his conversations with Russian Ambassador Kislyak in late December 2016, at a time when the United States had imposed sanctions on Russia for interfering with the 2016 presidential election, and Russia was considering its response. See Flynn's statement of offense. Flynn told agents that he did not ask Kislyak to refrain from escalating the situation in response to the United States' imposition of sanctions. That statement was false. On December 29, 2016, Flynn called Kislyak to request Russian restraint. Flynn made the call immediately after speaking to a senior transition team official, K.T. McFarland, about what to communicate to Kislyak. Flynn then spoke with McFarland again after the Kislyak call to report on the substance of that conversation. Flynn also falsely told the FBI that he did not remember a follow-up conversation in which Kislyak stated that Russia had chosen to moderate its response to the U.S. sanctions as a result of Flynn's request. On December 31, 2016, Flynn, in fact, had such a conversation with Kislyak, and he again spoke with McFarland within hours of the call to relay the substance of his conversation with Kislyak. See Flynn's statement of offense, section 3. Second, Flynn made false statements about calls he had previously made to representatives of Russia and other countries regarding a resolution submitted by Egypt to the United Nations Security Council on December 21, 2016. Specifically, Flynn stated that he only asked the country's positions on how they would vote on the resolution, and that he did not request that any of the countries take any particular action on the resolution. That statement was false. On December 22, 2016, Flynn called Kislyak, informing him of the incoming Trump administration's opposition to the resolution and requested that Russia vote against or delay the resolution. Flynn also falsely stated that Kislyak never described Russia's response to his December 22nd request regarding the resolution. Kislyak, in fact, told Flynn in a conversation on December 3, 2016, that Russia would not vote against the resolution if it came to a vote. See Flynn's Statement of Offense, Section 4. Flynn made these false statements to the FBI at a time when he was serving as National Security Advisor, and when the FBI had an open investigation into Russian interference in the 2016 presidential election, including the nature of any links between the Trump campaign and Russia. Flynn's false statements and omissions impeded and otherwise had a material impact on that ongoing investigation. Flynn's Statement of Offense, Section 1-2. They also came shortly before Flynn made separate submissions to the Department of Justice pursuant to FARA that also contained materially false statements and omissions. ID Section 5. Based on the tonality of that conduct, the office decided to charge Flynn with making false statements to the FBI in violation of 18 U.S.C. Section 1001A. On December 1st, 2017, and pursuant to a plea agreement, Flynn pleaded guilty to that charge and also admitted his false statements to the department in his FARA filing. CID plea agreement, United States versus Michael T. Flynn, number 117, CR 232, DDC, December 1st, 2017, document 3. Flynn is awaiting sentencing. Michael Cohen. Michael Cohen was the executive vice president and special counsel to the Trump Organization when Trump was president of the Trump Organization. Information, Section 1, United States versus Cohen, number 118, CR 850, SDNY, November 29, 2018, document 2, Cohen information. From the fall of 2015 through approximately June 2016, Cohen was involved in a project to build a Trump-branded tower and adjoining development in Moscow. The project was known as Trump Tower Moscow. In 2017, Cohen was called to testify before the House Permanent Select Committee on Intelligence, HPSCI, and the Senate Select Committee on Intelligence, SSCI, both of which were investigating Russian interference in the 2016 presidential election and possible links between Russia and the presidential campaigns. In late August 2017, in advance of his testimony, Cohen caused a 2-page statement to be sent to SSCI and HPSCI addressing Trump Tower Moscow. Cohen Information Section 2-3. The letter contained 3 representations relevant here. First, Cohen stated that the Trump Moscow project had ended in January 2016 and that he had briefed candidate Trump on the project only 3 times before making the unilateral decision to terminate it. Second, Cohen represented that he never agreed to travel to Russia in connection with the project and never considered asking Trump to travel for the project. Third, Cohen stated that if he did not recall any Russian government contact about the project, including any response to an email that he had sent to a Russian government email account. Cohen Information Section 4. Cohen later asked that his 2-page statement be incorporated into his testimony transcript before SSCI, and that he ultimately gave testimony to SSCI that was consistent with that statement. Cohen Information Section 5. Each of the foregoing representations in Cohen's 2-page statement was false and misleading. Consideration of the project had extended through approximately June 2016 and included more than 3 progress reports from Cohen to Trump. Cohen had discussed with Felix Sater his own travel to Russia as part of the project, and he had inquired about the possibility of Trump traveling there, both with the candidate himself and with senior campaign official Corey Lewandowski. Cohen did recall that he had received a response to the email that he sent to Russian government spokesman Dmitry Peskov, in particular, that he had received an email reply and had a follow-up phone conversation with an English-speaking assistant to Peskov in mid-January 2016. Cohen Information, Section 7. Cohen knew the statements in the letter to be false at that time and admitted that he made them in an effort to, 1, minimize the links between the project and Trump, who by this time was president, and 2, to give the false impression that the project had ended before the first vote in the Republican Party primary process in the hopes of limiting the ongoing Russian investigations. Given the nature of the false statements and the fact that he repeated them during his initial interview with the office, we charged Cohen with violating Section 1001 on November 29, 2018. Cohen pleaded guilty pursuant to a plea agreement to a single count information charging him with making false statements in a matter within the jurisdiction of the legislative branch in violation of 18 U.S.C. Section 1001 A, 2, and C. Cohen Information. The case was transferred to the district judge presiding over the separate prosecution of Cohen pursued by the Southern District of New York after referral from our office. On December 7, 2018, this office submitted a letter to that judge recommending that Cohen's cooperation with our investigation be taken into account in sentencing Cohen on both the false statements charge and the offenses in the Southern District prosecution. On December 12, 2018, the judge sentenced Cohen to 2 months of imprisonment on the false statements account, to run concurrently with a 36-month sentence imposed on the other counts. Jeff Sessions. As set forth in Volume 1, Section 4A6, Supra, the investigation established that while a U.S. Senator and a Trump campaign advisor, former Attorney General Jeff Sessions, interacted with Russian Ambassador Kislyak during the week of the Republican National Convention in July 2016, and again at a meeting in Sessions' Senate office in September 2016. The investigation also established that Sessions and Kislyak both attended a reception held before candidate Trump's foreign policy speech at the Mayflower Hotel in Washington, D.C. in April 2016, and that it is possible that they met briefly at that reception. The office considered whether, in light of these interactions, Sessions committed perjury before or made false statements to Congress in connection with his confirmation as Attorney General. In January 2017 testimony during his confirmation hearing, Sessions stated in response to a question about Trump campaign communications with the Russian government that he had been called a surrogate at a time or two in that campaign, and I did not have communications with the Russians. In written response submitted January 17, 2017, Sessions answered a no to a question asking whether he had been in contact with anyone connected to any part of the Russian government about the 2016 election, either before or after Election Day. And in March 2017, supplement to his testimony, Sessions identified 2 of the campaign period contacts with Ambassador Kislyak, noted above, which had been reported in the media following the January 2017 confirmation hearing. Sessions stated in the supplemental response that he did not recall any discussions with the Russian ambassador or any other representatives of the Russian government regarding the political campaign on these occasions or any other occasion. Although the investigation established that Sessions interacted with Kislyak on the occasions described above, and that Kislyak mentioned the presidential campaign on at least one occasion, the evidence is not sufficient to prove that Sessions gave knowingly false answers to Russia-related questions in light of the wording and context of those questions. With respect to Sessions' statement that he did not recall any discussions with the Russian ambassador regarding the political campaign, and that he had not been in contact with any Russian official about the 2016 election, the evidence concerning the nature of Sessions' interactions with Kislyak makes it plausible that Sessions did not recall discussing the campaign with Kislyak at the time of his statements. Similarly, while Sessions stated in his January 2017 oral testimony that he did not have any communications with Russians, he did so in response to a question that had linked such communications to an alleged continuing exchange of information between the Trump campaign and Russian government intermediaries. Sessions later explained to the Senate and to the office that he understood the question as narrowly calling for disclosure of interactions with Russians that involved the exchange of campaign information as distinguished from more routine contacts with the Russian nationals. Given the context in which the question was asked, that understanding is plausible. Accordingly, the office concluded that the evidence was insufficient to prove that Sessions was willfully untruthful in his answers and thus insufficient to obtain or sustain a conviction for perjury or false statements. Consistent with the principles of federal prosecution, the office therefore determined not to pursue charges against Sessions and informed his counsel of that decision in March 2018. Others interviewed during the investigation. The office considered whether, during the course of the investigation, other individuals interviewed either omitted material information or provided information determined to be false. Applying the principles of federal prosecution, the office did not seek criminal charges against any individuals other than those listed above. In some instances, that decision was due to evidentiary hurdles to proving falsity. In others, the office determined that the witness ultimately provided truthful information and that consideration of culpability, deterrence, and resource preservation weighed against prosecution. See Justice Manual, Section 9-7, 220, 97, 230.